All right, now those were views there from a cross-section of Nigerians indicating what they think should be the qualifications for persons who are seeking elective offices in our country. We have guests with us in the studios and also from one of our network center. Our regular guests on Good Morning Nigeria. Here in the Abuja studios, Menasara Kogo Umar is a lawyer and international analyst on democracy and good governance. Kogo, pleasure to have you on.
Good morning, Nigeria. Happy democratic practices.
All right. Also here with us in the studios is Oluwole Osaze Ozi, a legal practitioner and an election expert. Osaze Ozi, delighted to have you again on Good Morning Nigeria.
Thank you for having me. Good morning.
Thank you.
All right. Festus Oguche, a constitutional lawyer, joins us from our Port Harcourt studio also for this conversation. Mr. Oguche, it's good to see you. It's been a while.
Thank you very much. Thanks for inviting me.
So, gentlemen, once again, I'd delight to have you with us on to this conversation. It would appear on its own fairly straightforward that these are the qualifications you should have for you to seek elective office in Nigeria. But certainly it can be a complicated matter, as we have seen clear at the beginning of this conversation. We did say that parties are fully minded now. What happened 2 years ago, I referenced that when we were having a conversation yesterday on the primaries, where Bayelsa State was won by the APC in the governorship election, and the governor-elect was having a rehearsal for his inauguration. And then the Supreme Court on the 14th of February struck and said that his running mate did not meet the criteria for election, and therefore the ticket and the election collapsed. So let's bring in our guest right away, Menasara Kogo Umar.
Yes, sir.
I know that there have been broad issues, the number of criteria required. Let's begin to take them one after the other in terms of what makes an aspirant and ultimately a candidate eligible for election in Nigeria.
Fundamentally speaking, the primary one is that he should be a member of a political party. And then when you take it constitutionally, sections 66, 107, 137, 157, 189, all these provisions in respect of aspirations for state assembly, for governorship, for House of Representatives, for Senate, and the President, they have general and specific qualifications. The first general qualification is that you must be a Nigerian, a born citizen of Nigeria, or where you acquire citizenship of another country, you should not pronounce your allegiance to that country. Then number two is that you should be educated up to school certificate or equivalent level. The third one is that you should be, there are age reason. For example, the president 40 years, senators 35 years, governors 30 years, and the rest like that. You have to meet of the age requirement. And then apart from that, you have to meet certain fundamental requirements to especially enunciated under section 137. That has to do with the issue of your state of, what do you call it, sanity. You shouldn't be somebody adjudged to be of mental infirmity. Apart from that, you shouldn't be somebody who is adjudged bankrupt by a competent court of law. And then you should be somebody that has never been convicted on account of offenses of code of conduct. You should be somebody equally that has never faced charges of treason and other capital criminal offenses. And apart from that, you should be somebody that has contributed immensely to the success of your political party regarding something. Then there are some other statutory provisions that have added to that, to the constitutional. For example, when you take the provision of section 84 subsection 12 of the Electoral Act, because it's a statutory law subsisting as of now. Because since the pronouncement of the judgment by the Court of Appeal, and there has not been any counter that either stayed it or altered it. So it is a fundamental distinction that those members, those political functionaries who are called political appointees, those appointees, those mentioned under Section 147, Section 150, Section 174, Section 137, Section 171 and Section 173, even if you go by extension, Section 214 down to 218, those appointees, talking about ambassadors, service chiefs, talking about chief executives or parastatals, talking about ministers in respect of federal, commissioners in respect of state, members of the boards of government, parastatals, chairmen and members, all those appointees as far as Section 84 subsection 12 is concerned, they must resign before participating. If they are interested in participating in any election, they must resign before participating in the processes, either as an aspirant or as a delegate. They must resign in that context. And then it talks about another statutory provision too, talking about sections 66, 107, 137, 108 of the Constitution that says civil servants and public servants. For clarity, civil servants are those under employment of ministries. Public servants are those under employment of parastatals of government under the ministries, those under MDS. That those categories should resign 30 days before the general election. So if you don't resign and you participate in the processes of the party primaries as a political appointee, you have disqualified yourself before even the primaries. If you don't resign up to the time you are going into general elections as a civil servant or public servant, you cannot automatically, you have contested in nullity as far as the position of law is concerned.
All right.
So basically these are the statutory and constitutional requirements of qualification.
In fact, you had cycloramaed the whole issues really. Thank you, but we'll take them one after the other in the course of our conversation. But let's turn attention to Barrister Uzi here with us. Of course, Oluwole is a legal practitioner and election expert. I know that the Constitution, has gone quite a number of amendments and alterations with regards to eligibility to contest elections. Are there any that has really impacted, altered, added, or totally removed?
Well, yes. Recall that the most fundamental of the amendments undertaken regarding the qualification or disqualification, by the way, I should make the point that in dealing with eligibility, you have to talk about qualifying factors and disqualifying factors. So basically, you are qualified. But there are certain times that although you are qualified, you've met the, as my other friend has said, you've met the educational qualification, you have met the age, you're a Nigerian citizen. But there might be things that will disqualify you. I think it's enumerated some of them. For example, if you are undischarged bankrupt, or if you've been guilty of an offense involving dishonesty and things like that, you are otherwise qualified. You've met the criteria, but there are certain disqualifying factors that have come to play. Recall that in 2003, 2002, 2003, in the build up to 2003 elections, there used to be this provision in the Constitution which says that indictment by tribunal, and that was subject to quite a bit of abuse. Recall that the Iowa panel was now set up to indict, which indicted certain people, and this panel was set up very, very close to the elections. Some people alleged that they were not invited to the panel, but they were indicted by that panel. Then the provision was that if you are indicted by a panel and that indictment has been accepted by government, so you're not being convicted of a criminal offense, but just an administrative or judicial panel has indicted you. So recall that I think Abia State government, for example, indicted President Obasanjo as he was then and things like that, based on what they thought the federal government was doing. Some state governments also did similar things. So they invited them, indicted them, and I recall Abia State government, there's several governments that now went and did white papers and said, even for matters that were not within the province of the state governments, but they were dealing with federal officers and things like that, but they indicted, but just to follow and make those constitutional provisions. Because of that kind of controversy and potential for abuse, that provision was deleted from the Constitution when I think it was the first or second amendment that dealt with that. So, but basically, apart from that, most of the requirements for eligibility, whether qualifying or disqualifying, are still the same as they were in 1999 when the Constitution came into force. Those who contested 99 elections predicated their qualification and disqualification on the decrees, because each decree, we didn't have the 1999 Constitution. 1999 Constitution did not regulate the conduct of the transitional elections leading up to democracy in 1999. Each office, each seat was dealt with by decrees, and those decrees contained provisions for qualification. And quickly, I may just add that for governor and president, you have to be a Nigerian by birth. That's a distinguishing factor between legislative houses and executive positions of governor and president. Yes. So if you're a naturalized Nigerian, you can be a member of the house, you can be a senate, you can be a member of any house, but you cannot be a president. You must first of all be born Nigerian. Not necessarily born in Nigeria, but Nigerian by birth, which the Constitution has, maybe your father or your grandparents were Nigerians. And there's the issue you also said about a disqualifying factor. If you're a Nigerian by birth or a Nigerian and you have sworn allegiance to another country, I'm not aware of any case where that has been proven. But I know, for example, to be a U.S. citizen, you must renounce. You must renounce your citizenship of the country, and you swear allegiance to that other, to the US. You must swear allegiance to that country. So technically, if you can prove in a court of law in a tribunal that the person has dual nationality, is Nigerian and although born in Nigeria or Nigerian by birth, but has sworn allegiance to the US or any other country, that person is disqualified from contesting the election.
Menasa was talking about age eligibility,
yes.
and he mentioned the age of 40.
Yes.
And I think the Not Too Young to Run Act liberalized that.
Well, reduced, yes, correct. Some positions did not touch the president, for example.
Okay.
It reduced, and that was the confusion. Some people, the bill, as sponsored by the movement, Not Too Young, reduced all for all officers named in the Constitution for the State House of Assembly, National Assembly, and the Presidency. But in the consideration, National Assembly consideration of that, they did not touch that of the President, and I think that of the governors or so. But the main thing was that a lot of the contestants, soon after that bill was passed, thought that it was as passed by the bill. I
thought that for the President was reduced from 40 to 35.
Some offices it didn't affect all offices. Not all were reduced. So the bill was, I won't say amended, it was not as produced. It did not pass all the thresholds as produced by the bill.
Okay, that's part of the fourth alteration to the 1999 Constitution. Again, we'll get into the details of those provisions in the fourth alteration to the Constitution. We are being joined now by another, shall we say, regular guest on Good Morning Nigeria. Of course, is a national player, but he honors us with his regular presence on the program whenever we're discussing issues of this nature. Engineer Yabagi Yusuf Sani is a national chairman of the Inter-Party Advisory Council, and is also the chairman of a political party. Engineer Yabagi Sani, pleasure to have you with us on the program this morning.
Thank you, Kingsley. Good morning, Nigerians.
All right, so we'll come back to you later on. As the saying goes in law, where the equities are equal, first in time, first in right. We earlier introduced Festus Oguche, again a regular guest from our Port Harcourt Network studios. So we'll give him the shot now to let us into the broad strokes of what the eligibility and disqualifying criteria are for contesting election in Nigeria. Festus.
Thank you very much, Kingsley. The qualifications and disqualifications are merged into one by the Constitution and spells out the clear areas that makes one qualified or eligible for political positions, particularly the elective positions. These things are very normal in every constitutional framework to ensure that the people that emerge to lead are credible, and they go through the regular process of ascertaining not just their credibility but also their background and their orientation. These are very, very important. The fact of the Constitution coming out or reeling out these conditions are quite clear and understandable, in the sense that the political space must not be occupied by people who have questionable characters, or persons who are found wanting one way or the other by courts of competence, or persons who are not Nigerians, or persons who have served sentences or terms, or have been found guilty of the criminal act of dishonesty in any manner whatsoever, or persons who are not fit for those positions. If you expand it beyond that point, you'll also see that the Constitution did not mince words with regards to the qualifications for membership of the Senate, membership of the House of Representatives, the qualification for one to vie for the position of governor, the president, the deputies, and the vice. These are provided in the different provisions of the Constitution, section 65, 66, 107, 108, and the rest of them. And if you look at it broadly, you also see that in spite of these very noble goals, a lot of Osaze-Yamu had reeled out the fact that, well, in spite of these conditions, there are other many conditions beyond it, and which can be looked at, which are not actually written, but which form part of it. But we see that a lot of what is happening within our country gives us the impression that a lot of people who are not fit to be there are currently there. And that also explains why we have this factual situation that is beyond anybody's imagination. I am not saying that the process is not transparent, but I think we need a much more transparent process for the real persons, the real leaders to emerge. People with the proper quotient, people with the proper ideology, people with the focus, and not to look at political office as something, or elective office as something that adds only economic value to the aspirants. I'm talking in terms of looking at office as a self-serving device for people to show their worth, to show their quality, to show their exhibit their innate qualities for the good of mankind, or not for the good of themselves. But if you look at the political space as it is, most aspirations are on the basis of how to get money. By all means, the politics have become the easiest way to become a millionaire. And now we have a lot of novel rich millionaires all over the place who are more of the politicians. You find them more in the political circle than in other circles. But then it doesn't require the amendment of the Constitution to know that the process and the conditions stipulated thereunder are very, very clear and straightforward. There are also conditions under the Electoral Act, and there's also the activities of political parties that tend to bring in their own definition of eligibility outside the constitutional provisions. And we are saying, no, you must restrict yourself to the qualifications and disqualifications, the conditions for eligibility stated in the Constitution, because that is where the crux is. If you as a political party go to impose other qualifications that are well outside the realm of your power and well outside the realm of your mandate, constitutionally speaking, by virtue of law, the Electoral Act, then you are doing something that is contrary to the provisions of the Constitution, which is aberrational. Kingsley.
Okay.
All right. Thank you very much, Mr. Festus Oguche. We'll come back to you, Claire.
Yes, I actually wanted to, through the last part of his response to the national chairman of IPAC, that's Yapagi Yusuf Sani. Are there, what will I say? He said that the political parties are trying to kind of, impose their own understanding of eligibility. Is that true? Is that political parties trying to do that? What do you understand by eligibility for elections?
Well, thank you very much. Like you rightly said, we have to ensure that the person meets the constitutional requirement of becoming an aspirant or even candidate, as the case may be. But in addition to the issue of age, citizenship, and other constitutional requirements, you also need to be somebody that the party, like he says, looking at the constitutional, requirements, meet the aspiration of Nigerians, because yes, there are certain provisions of the Constitution, not only in the case of political parties, but in other cases. That's why you have, after the Constitution, you have Act of Parliaments that now gives administration of whatever the Constitution has said, to administer them, so that for the purpose of implementation and meeting the desirability, the desire of the intent rather of the Constitution, those cannot be written in black and white in the provision of the Constitution. So, and then you have Inec there for political parties, and you have political parties that also have things like, does this person really internalize the goal, the aspiration, of the political party? Is the person known to the party really? Has he been paying his dues, up to date? You can have a situation where somebody just wakes up, today, and say, okay, I want to be the president of this country. I want you to give me a platform. You don't even know this person. You don't know whether the person is a criminal. You don't know, all these things. So you must have. That is why the issue of the time, frame that INEC gave. Some of we, political parties were asking, we are saying that we need to make haste, slowly, so that we don't box ourselves into a situation where, after the exercise, you end up with so many litigations that may even affect, the process itself. That is the elections that we want to conduct. So yes, political parties have their own conditions, but they are not outside the law. They are in the fulfillment of intent of the provisions of the Constitution. Like, if you say somebody must meet his, dues to the party, that's nothing wrong, that. If the party says, okay, you have to be at least 1 month or 2 months, in the party, so we know who we are dealing with. We know who are preventing Nigerians. The Constitution is not just a piece of, the ground known that say political parties are just robots. That no, they expect you to bring to bear your experience, those things that your party stands for, so that going forward we'll be able to present to Nigerians and give Nigerians somebody that we know is credible, that has track records, that will take Nigeria to that promised land. With all the resources we have, and we know that if you cannot get recruitment of leadership right, believe you me, there's nothing you can do after somebody is already on the seat, like as a governor or as a president, as the case may be. So this is why you need time to ensure that you sift through whatever the person is given to you or your assessment of this person. That's why when you things that you find a political party saying, we want to know you, at least, let us know you for at least 1 month, or 3 months in most constitution of the parties. It's not because you want to stop anybody from running, but it's because you want to make sure that at the end of the day, when people are asking a party and they are saying things about the party, you can stand for that person and say, no, I know him that he's, of this character. I mean, he's of this personality, and he can meet the test of time.
So in addition to the provisions of the Constitution, political parties also do their own eligibility check.
Yes, of course. That's what we are expected to do. That's why we are the managers of political parties. That's why, even INEC expects you to ensure, and in fact, section 84, 29 or something like that, of the electoral law, says that if the national chairman of a party or the party presents somebody that his papers are false, or things like that, you are liable. You will be fined at least 10 million naira. It doesn't stop there. Your party will also be disqualified, and the person you bought will be disqualified. So it presupposes that they expect you to do due diligence, check, ensure that this person meets the requirement of the Constitution. And how else do you do it if you don't bring in things that will not be spelled out in the Constitution, like I said, so that at the end of the day you are now you are satisfied that the person I'm presenting will not in any way expose us to unnecessary litigations and or disqualification at the end of the day.
Chairman, I still want to stay with you. Part of what you have just explained now relates to the qualification criterion, namely that for you to contest election as provided for in the Constitution at the moment, you must belong to a political party. And for you to belong to a political party, there are also membership criteria. And the political party also has its own bylaws. That is to say, as bankers will say, know your customer, they will say, know your members. But In getting into the election season, such as we have been hearing, screening of aspirants, screening of that, could you tell us, and that's to say our viewers invariably, what does screening involve? And how does it happen that sometimes, the filtration process isn't so quite clean and parties run into windstorms?
Well, screening, amongst other things, means that does this person meet the requirement of the Constitution? After you have done that, that is of age, that he's somebody that is of sound mind, that is somebody that is a citizen of this country, and that is somebody, who does not have anything, as questionable character, because the parties want to be sure that, one, we know you means that you can represent us, because when you go to when you go for an election, the person's photograph or name is not on the ballot. It is the party symbol that be on the ballot. So in essence, it is the party that is being presented to the public that will present this person. So among other things, you want to also be sure that this man has met things like the nomination fees. Has he paid, or has he been given a waiver? And you also want to be sure that this person is not, like I said, somebody that will come and then disrupt, what you are doing in your party, because some people will come in for the purpose of just disrupting, the political party for the interest of maybe other people that may not be members of your party. So that's why parties carry out this due diligence to ensure that you are presenting to INEC, you are presenting to Nigerians, you want two things are here: qualification and also the competence that the person can represent your party. So these are the things that we have, and the requirements is that, like I said before, you are in the party for at least some few weeks or few months. Actually, in most constitutions they have at least 3 months. It is not the intention of the constitution that just bring anybody you want. If the person meets the constitution, no. They expect us to do due diligence, and that's what we normally do. Nothing. And when people are disqualified, they are disqualified because the party has discovered that this man, by all standards, does not, have the requirements. Maybe even in terms of qualification, does he have the minimum qualification? Is his papers not questionable? Is he presenting a questionable credential that he has this qualification? He doesn't have it, or So these things are things that parties must do, because INEC is not charged with responsibility to check these papers or something like that. Once you present, INEC will take it and will present the person, because he's presenting your party. And then if somebody goes to court that, no, this man's papers are not, all right, it is the party now that will be responsible, not INEC, not the individual.
Which leads us to the next question, to Oluwole Osaze-Ozi. What is the role of INEC in the filtration process for qualification or disqualification? Because a ground for disqualification is the presentation of false claims to the Independent National Electoral Commission. So what does INEC do? Is INEC merely a receptacle for the papers that are dumped on it?
It's hard to say. The more current thinking seems to suggest that. Prior to 2007, Inec was acting both as a manager of the process and as a regulator. And in its regulatory functions, it felt that there are certain provisions of the Constitution that are not self-executing. In other words, somebody has to kickstart the process. As a regulator, you look to see, is there compliance with the law or with the Constitution? If there's no compliance, Inec, then the attitude was that then we'll look at it and say, no, sorry, you're not qualified. And Inec used to screen. And that is what the law now has more or less shifted that burden to the parties, and as the chairman IPAC said, parties can be punished if they don't do proper screening. But left to me, it should not just be a receptacle, there should be a filtration process. So you have, for example, Inec has tried to play that role, but is very conscious of the history and judicial intervention in this regard. Recall that Atiku Abubakar, for example, He was allegedly indicted and everything else, and it was accepted by government and was going to be excluded from the 2007 election. Abubakar in Kogi was excluded by Inec based on indictments and stuff like that. Now, certain people were bagatelled in Adamawa, so certain people were indicted, government accepted based on that, predicated on that. Inec did not put them on the ballot. It was said that Inec disqualified them, and the court said, look, it is not your role. That is not the function of Inec. Inec should not be the one to say whether a person is disqualified. It is a court of law to say whether a person, that's the function given, donated to the courts by the same constitution that created Inec. So that was the issue. So it's now a very, very tightrope. But recall in Kogi, in 4 or 5 years ago, I recall Akpoti was going to contest, but said, look, your running mate, your deputy, is less than the age, because of which not too young to run controversy. And she said, I googled it and I saw in the bill, not in the act, that he had met the age of 35, but it had been reduced from 35 to 34. I said that might have been the bill, but that was not the bill as passed, and which it did not become the act. It wasn't what was presented to the president, so not what the president assented to, so it did not become an act. A bill is a proposal. Until National Assembly debates it, passes it, and it's assented to by the president, or is overridden by the National veto is overridden by the National Assembly, it does. So you don't look at what was presented, you look at the end product, the finished product. So now there's this issue. So if a party should present somebody who's not a Nigerian citizen, for example, I say, I'm not a Nigerian citizen, I'm a Ghanaian, but I came to Nigeria, I may have that by default, or I'm 17 years old, I don't meet the criteria. Should Inec fold his arms, shut his eyes? That's what a lot of people seem to be saying. It sounds ridiculous, but that's the way it is, that until you go to court and get a court pronouncement, you cannot, and that surely cannot be the spirit behind the letter. Everybody should give effect to the Constitution. That's another constitutional provision. Everybody should ensure, every government institution and every citizen to give effect to the Constitution. So what role does Inec have to play in this? It's a very good question, and it's something that Nigerians should really, really debate. Are these provisions self-executing? The Constitution says the only one that may not be is that if you present a forged certificate to Inec, that's a disqualifying factor. Now, apart from the fact that whether if you present a marriage certificate, that's I don't know, but it says if you present a forged certificate, if it's agreed as the forged certificate, so Inec should also shut its eyes, fold its arms, and say, okay, you go to court. Let the court pronounce first of all that's a forged certificate. And don't forget, the chairman IPAC made allusions to the fact that these things, Inec gets this particulars from candidates and then publishes them. Now, the law before that, any Nigerian could challenge, anybody, any citizen could challenge that thing. But now, it is only an aspirant who was involved with that person in that particular party that can do so. So it has constricted and seriously narrowed the scope of those who can challenge. So by default, somebody who's not qualified, might not be a Nigerian citizen, is not up to age, does not have the requisite educational qualification, by default, may go and become a president, a governor, or a lawmaker, because you say these things are not self-executing, and you must challenge it in court, and the court must pronounce on it first of all. So if the president files 15 days after the cause of action arose, maybe 15 days, your statute back on technical grounds, the person becomes an office holder. These are some salient issues that we should consider.
Claire, let me let me ask the other question, because we're releasing Sazel Z shortly. What is the nature of the forms completed by the candidates and therefore their political parties? Is there an attestation requirement? That is to say, you appear before a judge and you get it attested, and therefore it becomes one on oath. If there are false claims, aside from the sanctions provided, there could be grounds for criminal prosecution. What do we know about the fields to be completed in the forms that candidates and parties submit?
Okay, the parties have their own forms, which they modeled. I think they got a pro forma from president from the Inec forms, and these are oaths, because the Electoral Act says you present your personal particulars and you swear to an oath. So to merge it, to Inec design the form, which is designed as form of an oath, which you have to take. It gives you the fields, your name, your age, your particulars. Have you ever been convicted? Have you ever done this? The qualifying issues are stated in form of a questionnaire, which you have to answer. Do you have are you qualified as your educational qualification? then attach credentials if possible. So you're now presenting the thing. What some people smartly do say, yes, these days, a lot of people now say, I recall somebody who said he had a PhD, for example, and did not have did not show from his O level or the SSE certificate that he was qualified to even proceed for an undergraduate program, but said he had a PhD and put the thing. It was challenged in court, but the case was already withdrawn. So they encourage you to put what you have, but it's for you, up to you to now attach these things. So it desires as a questionnaire. You fill those forms, you sign before a commissioner for oath. You take it to a notary public or commissioner for oath, take it to court and swear to it. So it becomes an oath. And right, if it's an oath, then if you lie on oath, that is a perjury, that's a criminal offense. And then the party, that's for the candidate themselves. And that is the form, copy of that form that will be displayed to the public to see the claims you have produced before the commission. But it's not a presentation of false information to Inec per se. It's not a disqualifying factor in the Constitution. Because if it's perjury, technically you should go before a court and the court has to pronounce that you are perjured, that you have sworn to a false claim. It is presentation of a false certificate. So that will be the certificate that you present to Inec, not that form itself. Although there are decisions of the courts that seem to suggest that the form used to be CF001 is actually a certificate for purposes of interpretation. But on a literal construction, you will not see that in the Constitution, but it says it's a certificate. So when you present that to Inec, Inec cannot say, oh, and so look and say, no, you are not qualified, you are underage, you are not a Nigerian. Inec cannot say so, it will appear. You have to go to court.
Just before we let you go,
Yes.
in less than 60 seconds, just clarify for us, because a lot of people, Nigerians out there, keep wondering why. If having a case or a romance, in quotes now, with any of the anti-graft agencies,
Yes.
specifically the EFCC, could that be a disqualifying factor? And if not, why not?
Well, the Constitution talks about having been convicted of an offense. You can be charged, and I think somebody said something about being charged with truth. No. You have to be convicted of the offense before that becomes a disqualifying factor. So no matter how notorious, there are certain people in this country we know, we call them 419, they are fraudsters, they are advanced fee fraudsters, they are criminals, some people are alleged, some others are murderers, but unless and until they've been convicted by a competent court of law, they cannot be disqualified. And that's why a lot of people confuse that also with the rule of Inec and say, there are so many criminals in National Assembly. Why doesn't Inec do anything? Inec does not have such powers. Nobody has such powers until those people have been convicted of those offenses. Now, that sounds like a good thing, and it is a good thing, because if it wasn't so, then a lot of people will have been charged to court. If I'm a governor, for example, I get the attorney general or my director of public prosecutions and I say, I don't like this man's face. He's a rival to me. I will charge him to court. It might be a frivolous charge, but if you say you want to disqualify him because he has been charged to court, then until he runs through the gamut, and don't forget that in your paper review, for example, I saw that the former NSA's Sambo's case is going to start de novo, going to start afresh after 7 years. Now, if, for example, he was interested in contesting an election, he may not found not guilty at the end of the day. He may or may not be. But if you were to disqualify him now, they can just drag those cases for years and years and years. So in everything you try to do, there's always a flip side. So yes, we shouldn't. It seems wrong. Don't forget that Omishore was in custody when he won election. Oji, former governor of Abuja State, was in custody when he won election. That just goes to tell you that, look, yes, he might be facing charges. There are several people now who pick presidential forms, who pick governorship forms, national assembly forms, who are facing serious corruption charges. So, charged to court. One, for example, was convicted. But the Supreme Court reversed that conviction and sent it for retrial. So unless and until there's a conviction and there's no retrial, that, you cannot disqualify the person.
Okay. Clear. We are tempted to, but he has to. Sazia Uzi, a regular on Good Morning Nigeria, legal practitioner and an election law expert, has been with us for today's conversation. We'd like to appreciate you.
Thank you.
We do hope we have the benefit of your contribution some other time. Thanks a lot.
Thank you.
Well, let's return to the other guests. Umar Kogo. I understand we have to take a short break now. When we return from the break, I will be kicking off from where Sazia Uzi stopped, which is to say that you have been convicted. But we know that there is also a caveat to that conviction, if you're convicted in the court of first instance, what happens if your matter is on appeal? All right, we'll take a short break now. When we return, we'll continue with the conversation. All right, you're welcome back, and it's still Good Morning Nigeria, live on the network service of the Nigerian Television Authority. Now back to the studios. Menasara Kogo Uma, we're talking about the qualification and disqualification for elective positions. Quite a number of perspectives have been introduced by you guests, and so Sazeuzi, before we signed him off, was talking about conviction for an offense relating, for instance, to fraud or dishonesty.
Yes.
But I was also saying before we went on that break that there is a caveat even to that conviction. And that caveat meaning if you've been convicted, say the court of first instance, and you have not exhausted all your rights of appeal, that may not kick in. Let's have your views on this, as well as other relevant matters relating to eligibility for elections.
Yes, constitutionally speaking, Section 36 of the Constitution says that even if your offenses are as humongous as the combination of Zuma Rock and Olumo Rock, you are adjudged to be a free person of no blame until adjudged so by a competent court of law. So that presumption of innocence until adjudged guilty by a court of law, gives you the latitude to really go ahead to establish your innocence, or those that are accusing you to be able to establish your guilt. And that has been clinically stated in the Constitution when you take sections 230, 231, 230, up to 304. There are rooms for appeals. Now, where a lower court convicts somebody, certain conditions must be established. Number one, you are convicted, but if it's not served, it cannot take effect. But where it is served again and you decided to go on appeal, your appeal will still not stop the execution of that judgment until you get what is called stay of execution. When you get the stay of execution, pending the determination of the substantive matter at the appeal level, then on that basis, you got a halt. You got a halt because the ultimate of it is the determination by the upper court, which continues moving upwards up to the highest court of the land, which is the Supreme Court. So until you get Supreme Court pronouncement, or until members of the legislature in their own wisdom decided to use their power under sections 4, 11, 8, and 9 of the Constitution and decide to delete that item to make it not become an offense. Because there must be establishment that yes, so misdemeanor one is exhibited is Christian as an offense in our own records of law. Otherwise, if it is not there, if there is no law that says that you are guilty of this is a criminal something, then you cannot convict. But there are so many other checks that both the electoral umpire and the political parties can exploit. For example, under Section 34 of the Electoral Act, that forbids that the parties should conduct primaries. It says that where a party conduct the primaries without representation of Inec, that primary is a nullity. And then Section 65 says that where there are evidence of duress, or where there are evidence of some undue practices during the primaries, that INEC has not been given the power to review those primaries without allowing it to just go ahead like that. So there are some conditions, like we said, when you get the form, for example, one of the parties introduced this idea of voluntary withdrawal. You fill it, you attach it to the form, so that ultimately when consensus is reached, that one will be used as the instrument that yes, you voluntarily withdrew for Madam Claire in the interest of party cohesion, party discipline, and party progression. So, but where somebody now decides to say, no, this will infringe on my fundamental rights as per the provision of section 33 up to 44 of the Constitution. Obviously, you know, the party can decide to disqualify him on that, to say that he is not being obedient to the rules of the party. But if he decides to now challenge it, he can win. And another thing is that when you take the position of the Constitution, section 221 down to 228 chronicles activities of political parties. For example, when you take 225 talking about the issue of finances, the issue of how the party should raise finances. Now, you discover that most of the political parties will stay aloof. Greater number of them do not have index of the membership register. At the grassroots level, at the local government level, at the state level, they don't have. So they don't have even basis to be collecting membership fee, membership dues, and the rest, and the rest. But paradoxically, when it comes to the issue of filling the membership form, there is a column there at the back of it where it shows evidence that you have been regular in payment of membership dues of the party, and as a condition which they will integrate into so amount for the period, which if you have not been paying, it can be a basis to screen you out. And then on that basis, parties are exploiting the window of that leverage given to them to be imposing some money. Say when you want to contest, you have to pay so amount, whether you call it peanut or whether you call it exorbitant amount. It depends on really the weight of your purse. Okay. So, and apart from that, another very fundamental thing has to do with the issue of party membership. Section 221, 22, especially 223. You'll discover somebody, for example, I can decide without resigning as secretary board of trustee of my party, or as member, bona fide member or foundation member of my party. It will not be surprising in Nigeria if tomorrow I become a presidential candidate in my next, the other party, or if I become even national chairman of the other party. You'll discover so many officers, foundation officers of this party, without evidence of yes, you'll see them tomorrow as imagine as the leaders of the other party, or somebody that is still this thing. For example, there is one of the aspirants that it marveled me within this week that his party is saying that come, we'll give you wherever you will be a candidate, and the other party too is saying, oh, we'll arrange consensus and give you the slot. So all those kind of things are talking about how disciplined, what are the ethics, what ethics have our political parties and political functionaries developed over the period of ages, especially in tandem with the provision of the Constitution, sections 21, 23, and 24.
Thank you. Let's put you on hold for a while. Festus Oguche is in Port Harcourt, and Festus, I'd like you to talk to us about tax payment defaults in other climes. This is a very serious offense, you know, that could affect one's political aspirations. Is it one of the disqualifying factors, criteria for eligibility?
It is not just a disqualifying factor for eligibility concerning election. It disqualifies you for everything. It's a crime to defy your tax obligations. To the extent that I know, taxation is one of the basic principles of statehood, upon which the state can not just garner financial resources to itself, but get the commitment of the citizenry. If you defy in making your obligations in terms of payment of taxes, which I know that a lot of Nigerians are involved in, you are totally disqualified from doing anything. As a matter of fact, it can even disqualify you from the citizenship of this country, except for the fact that the laws are there to punish you for trying to railroad or derail from your obligations as a citizen to your own country. I think it's a very good disqualifying factor.
I still want to stay with you, Mr. Festus Oguche. When usually in the popular thinking, reference is made to disqualifying factors such as conviction for dishonesty or fraud, and the Constitution, of course, brackets that by saying fraud by whatever name called. Reference often is made embezzlement of public funds and so on and so forth. I was wondering, very little is often said, even though tribunals are mentioned also in the disqualifying factors in terms of trial and conviction and sentencing. For instance, if a person or a candidate is a member of board of directors, and the directors of the company, are arraigned by, say, the IST or other competent authority. And we have had instances where quoted companies have had their directors sanctioned on account of fraudulent misrepresentation in their various statements of accounts. Would that also not act as a disqualifying factor of those named directors who sometimes have been barred from holding directorships for anything from 5 to 10 years?
The question, the answer is right in the question. It's implicit in the question you asked. But I do know very well that such acts of directors getting involved in fraud, or anybody at all, no matter who, getting involved in fraud, acts that are can be serious factors for eligibility consideration if it comes before a competent tribunal. It has to go to a tribunal first of all, because at that point it is the courts that can determine whether that act amounts to fraud or not. It is not prima facie fraud simply because there are documents suggesting there are frauds. They have to be looked at by competent courts. Straightforwardly, I will say that the eligibility for participating in the political process tries as much as possible. If you look at it from the constitutional framework and from the Electoral Act, it tends to suggest a thorough, transparent process. Very thorough, transparent process. But if the subject matter is still within the investigatory powers of the law enforcement authorities, or it's still a matter that is pending before a court of competence, of course, it does not amount to outright disqualification per se until pronouncements are made to that effect that these gentlemen are involved in fraud and dishonesty.
Just let me remain with you. One more question before we bring in the national chairman of IPAC. I like for you to explain to us again. This matter has come up in the case of one of the, our former political leaders' aspirations. It's in reference to Section 1373, which deals with the tenure, or the number of times one can one is eligible to contest any elected position. Can you clarify that for us, and what it means for those who probably will fall within that category?
Is constitutionally provided. It's also under the Electoral Act, and if a certain tenure is provided for a particular office, it must be followed strictly. For those who may want to come in to try their lucks, to test their grounds, probably because they have 100 million naira or so much million naira to pay as nomination forms and expression of interest forms, that's a different kettle of fish altogether. But where the tenure is expressly stated, it must be followed strictly to that rule. And those tenures are a direct consequence of maybe what the Constitution intends for people who want to stay in political office, not beyond certain terms, not beyond certain period of time. And when it comes to that, of course, the provisions will prevail.
Mr. Oguche, thank you very much. Let's bring in the national chairman of IPAC. I just want to stay with this question. I know that there are legal implications, and Kogo is itching to respond to it. It all forms part of the fourth alteration to the Constitution, of course, based on our experience with the late Umar Musa Yar'Adua and the ascension of President Goodluck Jonathan. What is do we have any semblance of that kicking into effect? Say at the state level, there appears to be no such thing to my thinking, namely that if a deputy or a vice president completes the tenure of his or her principal, then for that vice president or that deputy, that completion of that tenure will be deemed to be his own first term and cannot run for a third term, as it were. It can only be entitled to an additional one term. Even if it's for 1 day, you can only do 4 years. After that, you are disqualified from running again. Do we have any such circumstances arising now at the state level?
Is that a question for me?
Yes, please. Yes.
Yeah, well, I don't, well, we might have, but I think the spirit of the Constitution is not intended to differentiate anybody. And then, because if your principal, for instance, goes on leave or for any reason, maybe was sick for a while, and then you now, superintend over the affairs of the state, it doesn't mean that when you finish your term, they will say, no, you were, when your principal was not, feeling, was outside the country, or maybe was in the hospital or things like that, you presided over the state of the affairs of the state. So I don't think, even at the national level, it should be interpreted to mean that way, that once you act on behalf of your principal, that disqualifies you. I don't think that is the intention of the Constitution.
No, Chairman.
Yes.
That's not precisely what the Constitution provides.
Yeah.
It said that you have acted. It is where the individual completes the unexpired tenure of his principal, who is removed from office. Kogo, you may wish to pitch in here before we bring in again the chairman.
Yes, I was trying to recapitulate even the date, because there are two scenarios to it. Number one, there's a law that has been enacted by the National Assembly, which was signed by the president. I think it was 2017. I'm trying to recall the particular date even. I think it's
June
20...
June 7th?
Oh, yes.
Came into effect?
Yes.
2018.
So that one clearly, uncontrovertibly, encapsulates both at the federal level, at the state level, and at the local government. Say, where as a deputy or as a running mate to a joint ticket, that is whether you call it deputy governor or you call it vice president, for any reason, whether it's impeachment, whether it's death, whether it's removal on health ground, or whether it's removal by court, you as the running mate, got sworn in to complete the tenure for that the particular listing, then you can only be sworn in one more time. In other words, you can only contest one more time, because that one is a joint ticket, and that is in tandem with the provision of Section 137 of the Constitution. So you cannot be sworn in 3 times for that particular same office. That is the position of the law in a situation whereby before that particular enactment, there were instances of people that serve up to 3 terms. But the position of the law is that from the day it is enacted, it comes into force. Whatever happens before is history. But from that date up to now, it has not been repealed, and that is the position of the law. Nobody can be sworn in up to 3 times for a particular post. So if you, for example, I as the principal, I died, you as my running mate, you got sworn in to fill up my tenure, either I die or I'm impeached or court sack me or for whatever reason, then you have done 1 tenure. You can contest election again, you win 2nd tenure, but that is the end. There is no provision for the only.
I was going to ask you if there was a caveat for any candidate for a 3rd term.
No, there is no caveat whatsoever. There is no caveat. The only people, the only category of politicians that have the leverage to go for an unrestricted tenure are the legislature. The members of the legislature have an unrestricted tenure as far as that is concerned.
Well, in the primaries conducted at the weekend, there was a news out of Enugu State that a member of the House of Representatives on the platform of the PDP, who was seeking a 5th term in the House of Reps had lost the primaries. That's in Nsukka Igbo is a federal constituency. So he'd been in the National Assembly for 4 terms, and that's 16 years. But there is a tricky aspect. Again, this is legal and constitutional. Section 28, and this was introduced under the administration of General Ibrahim Babangida, dual citizenship that we now have in the Constitution, Section 28.
Yes.
And yet, dual citizenship, which Oluwalozi mentioned earlier, say, for instance, you are acquiring the citizenship of any other country. I would imagine that there's a requirement for you to swear allegiance to that country.
Yes.
If you acquire the citizenship, and this could also be a disqualifying factor for certain elective positions in Nigeria.
Yes. Fundamentally speaking, the law is very, very clear. You cannot acquire citizenship of any country without showing your allegiance to that country. It is impossible. It is a case of, say, you are having life without blood. Definitely, anybody that acquires the citizenship, Nigerian political, what do I call it, inspectors should better begin to enforce this with all seriousness. We have assemblage of laws, but the implementation of them is the enigma in Nigeria's political terrain. For example, when you take Section 94 of the Electoral Act that says you cannot start campaign until 150 days, or Section 26, they are still on course that within 180 days you submit the list of, but Section 94, like I said, that says you cannot start until 150 days to election. But practically what is going on now is campaign in full swing. You see politicians going, they said, I want to consult with, what do you call it, delegates. I want to consult with delegates. They are bamboozling you every time in the media with jingles, with advertisements, billboards, and other things, posters, and then other things to such an extent that we have started witnessing assaults and intimidations and so many things in part of the DC. These are clear cases of violation of the Electoral Act itself. So Inec has been given the provisions of superintending activities leading to elections, but unfortunately they don't have the police. They don't have the means to detain culprits. They don't have the mechanism to enforce it. That has been restricted to the police under Section 214 to 216, and by extension, other law enforcement agencies up to 218. So, yes.
All right, Kogo, thank you very much. IPAC chairman, let's get your closing thoughts on this. I mean, you've been insistent on the closeness of the deadline by INEC for parties to complete their primaries and submit the list of the candidates. We have barely 2 weeks to that deadline. Is there any emergency in the air?
Well, there's no emergency except that, like we said, anything done in a haste, you are bound to make mistakes. We don't want this electoral law to become an accident waiting to happen to our democratic journey in entrenching a good governance in this country through democracy. That's why we are saying that be allowed to sift through, bring out quality candidates, so that going forward we have the kind of leadership that Nigeria deserves. And let me quickly also mention this issue of qualification, disqualification. Political parties normally, like these primaries that are coming, political parties will have 3 documents that are legal by implication. The guidelines that political parties bring out, to conduct the primaries, the constitution of the political parties themselves, the electoral law, and also the constitution. So all these things are what we put together and then conduct the primaries. It's not just on the constitution itself.
All right. Sorry, I have to stop you and get Barrister Guche's last words. Barrister Guche, you may also wish to speak on maybe falsification or irregularities in the data, that maybe candidates present as a factor for, disqualification.
The last speaker talked about things that are waiting to happen. I think what's most important here is the current practice of the political parties to impose high fees as the nomination for purchase of nomination forms. And that is completely outside the provisions of the Constitution. It's an attack on political democracy. The provisions of the Electoral Act at Section 84 clearly states that a party shall not impose any other term or any condition or any measure or criteria for political participation. And it goes contrary to the provisions of Section 224 and Chapter 2 relating to the fundamental objectives and directive principles of state policy. Now, by that mode of eligibility, you have excluded the majority of the demography from political participation. And it's an enthronement of a system of government we call political plutocracy. You cannot enthrone a plutocratic order over and above a democratic order. No, that is contrary to Section 2, subsection 1 of the Constitution. And I was awaiting for Inec to impose, to invoke its powers under Section 83 of the Electoral Act and the relevant provisions of the Constitution to monitor the political parties and punish those ones that are doing this. Because you cannot exclude somebody. Sorry.
You speak as if the program is just starting. I'm sorry, I have to interrupt you here because we've run out of time really. But we do appreciate the points that you were raising. That would have generated another round of conversation. But thank you, Festus Oguche, constitutional lawyer, joining us from studios in Port Harcourt. Always a pleasure to have you on the program.
Thanks.
And also here with us in the studio, we have May Nasra Kogo Umar, international analyst on democracy and nation building. He's also a lawyer. Thank you very much for your in-depth perspective.
Thank you very much. Thank you very much.
Yes, we also have Yabagi Yusuf Sani, national chairman, IPAC. Always a pleasure, sir, to have you join us. And we do hope you have your wish.
Thank you very much. Yes,
all right. And let's quickly take a look at the world of sports.
That's Good Morning Nigeria for today. As always, we appreciate your tuning in. The program is back tomorrow, same time, 7 in the morning. I'm Kingsley.